This program is brought to you by Emory University.
Okay, if we could get started, we have to, despite the fact that we're starting a little bit late for panel 2, we have to finish on time because I'm told that we have to set up for panel 3 and that there's some special factors involved in that because one of the panelists is going to be presenting remotely rather than from here at Emory Law School. So I will also be this is for the benefit of the panel, I am the time Nazi on this panel. And so we're going to do 12 minutes for each of the 4 presenters, and I'll provide a 1-minute warning signal, and then after that I'll probably have my cell phone alarm ring. That'll end it promptly so we can move on, and I do want to have some time for questions at the end because I think especially with the content of this particular part of the program that there will be questions and that there are going to be some things that we perhaps fortuitously don't hit on in terms of new technology issues that would be useful and useful to explore in the question and answer period. So, you know, the basic thing about this panel is that new technologies stretch legal frameworks. Harold Coe said it very well this morning when he said the problem is one of translation of general principles, whether constitutional, international law, statutory, whatever, to new situations. So new technologies stretch legal frameworks in the national security area with great regularity. National security, secondly, stretches frameworks that we normally operate under, such as civil liberties and rule of law frameworks. Again, Harold introduced the topic, and new technologies push the boundaries of national security and of civil liberties and rule of law issues. You know, we're going to talk about how various technologies, especially those related to the internet, related to new surveillance technologies, related to drones, and perhaps we'll get into autonomous robots and the like, at least in the question and answer period, operate in this field. So, you know, Robert Shapiro talked about oceans being the greatest protection for this country in the early days. Well, just think about it, if you will, that we've moved from clipper ships to steamships to submarines to aircraft carriers. We've moved from cannons to ICBMs. We've moved from dynamite to atom bombs. We've moved from postal service to telegraph, internet, and telegraph, telephone, and internet. All these movements of technology change the borders of our comfort zone for national security protection. And as those things have occurred, they've required us to look at the legal frameworks anew and to reconstitute those legal frameworks and reinterpret them to modern times. So I'm not going to repeat the introductions that are in the Thrower Symposium booklet. These are all enormously accomplished people to be talking on the New Technologies panel. So I'll add a couple of things as I introduce each one, and I'll introduce each one separately. I'm not going to do all 4 at once because then you'll forget the 4th one before she gets to speak, and that wouldn't be fair. So, and I want to be fair. So first of all, in addition to everything that's in your booklet about Laura Donahue, I just want to say a couple of things. One, a book that was mentioned came out. She brought a copy just hot off the presses today of her new book called The Future of Foreign Intelligence, Privacy and Surveillance in a Digital Age, Oxford University Press. This is one of the first 8 copies off the press, so brand new. Laura also has been on sabbatical, and I asked her what she used her sabbatical for, and part of it at least has been devoted to building a drone using, if you can believe this, 3D printing technology, templates off the internet, and other information. So certainly someone who is willing to explore the technical issues, not just the legal issues. I did want to make one special comment on Laura's behalf. She was very recently appointed as one of 5 amici in the FISA, the Foreign Intelligence Surveillance Court processes, and which was required under the USA Freedom Act last June. And so she can't comment directly on those processes and things in that area. But generally, here's what I think she's going to cover. The interplay between technology and Fourth Amendment doctrine in 3 different ways. Metadata, content, and non-content issues. Location tracking in light of public and private dichotomies that may not hold up, and international versus national, foreign versus domestic issues, and how these things kind of fit together and break down. Thanks, Laura.
Thank you very much, Charlie, and thank you to Dean Shapiro, also to Lori Blank, to Katya, Mary Grace, Matt, and all the organizers. This really is a truly impressive symposium, and I'm grateful to be part of today's discussions. As a scholar, one of the issues that keeps me up at night and on which I am spending much of my waking hours centers on the tension between technology and the law. To put it succinctly, Fourth Amendment doctrines created in the 1970s and 1980s no longer reflect how the world works. Technology has propelled us into a new era, and so rights are now under siege, not merely from government overreach, but from characteristics that are unique to technology. What are these traits? Well, digital information is non-terrestrial. It is borderless. Bits and bytes populate an alternative world. They may be held on a server, but data generation, its transfer, the availability, the analysis, it's not tied to territory, which undermines doctrines that rely on 3-dimensional geography. Technology also embodies an efficiency drive, so innovation makes it possible to do more, to do it better, and to do it faster than before. So doctrines that fail to recognize any privacy interest at the outset similarly are failing to account for the back-end privacy implications of more and more information being collected and analyzed with deeper privacy implications. Enormous amounts of digital information are now available, even as our ability to conduct our daily lives has become heavily dependent on these technologies. It is a non-option to eschew the digital world if you want to live in the contemporary world. These traits really clash with the structure of Fourth Amendment doctrine. Many of the formal distinctions are breaking down, and today I'm going to focus on 3 of them. First of all is the public versus private distinction in Fourth Amendment law. Second is the content versus non-content. And third is domestic versus international. Now, Fourth Amendment doctrine on the public versus private distinction has long relied upon the importance of protecting people within their homes from governmental intrusion. This approach really drew from English law. Remember, Sir Edward Coke famously declared in 1603 in Semane's case that the house of everyone is to him as his castle and fortress, as well for his defense against injury and violence as for his repose. Matthew Hale, William Hawkins, Lord Mansfield, Lord Camden, and other 18th century jurists picked up on this concept to protect the home. In 1766, the colonial hero William Pitt famously declared in Parliament, "Every man's house is called his castle." Why? Because it is surrounded by a moat or defended by a wall? No. The poorest man may, in his cottage, bid defiance to all the forces of the crown. It may be frail, its roof may shake, the wind may blow through it, the storm may enter, but the King of England may not enter. All his forces dare not cross the threshold of the ruined tenement. And as Englishmen, colonists embraced this concept of the home. In his famous oration in Paxton's case, James Otis explained one of the most essential branches of English liberty is the freedom of one's house. A man's house is his castle, and whilst he is quiet, he is as well guarded as a prince in his castle. Now, the Fourth Amendment cemented that understanding into our Constitution, prohibiting limiting exercise of government power inside the home, absent a specific warrant, supported by oath or affirmation, relating to a named offense, and particularly describing the place or persons to be searched or persons or things to be seized. In contrast, Fourth Amendment doctrine affords what people do in the public considerably less protection. And for centuries, this distinction held with the line drawn at the curtilage of the home. In 1967, Katz replaced the doctrine, trespass doctrine articulated in Olmsted and its progeny, with one that was based on a reasonable expectation of privacy. But even post-Katz, this private-public distinction held. So in 1974, in a case called Air Pollution Variance Board versus Western Alpha Corporation, a Colorado inspector entered an individual's home to measure plumes of smoke coming out of the chimney. The court underscored the open fields doctrine it had established in Hester. A decade later, it reiterated its position in a case called Oliver versus United States, when the Kentucky State Police search went into a homeowner's field that had been surrounded by a gate and marked no trespassing. Fields, by definition, were neither a house nor an effect. Now, although three justices in that case, Thurgood Marshall, William Brennan, and John P. Stevens, disagreed, the case made it clear that Katz had not changed the basic tenets of the open fields doctrine. And in 1987, United States v. Dunn continued the tradition. That approach carried over to new technologies. In the 1982 case of California versus Serralo, a plane flying 1,000 feet above a home in Santa Clara, my hometown, California, it fell outside the contours of the Fourth Amendment. What any citizen could see with their naked eye could not be denied to the government. The same day that the court handed down Serralo, it issued an opinion in Dow Chemical versus United States. The company had no privacy interest in what could be seen from the air over its facilities. The same held true for a helicopter flying just over the home. Despite a Florida citizen's efforts to post his property with signs saying, "Do not enter," law enforcement could hover above the house and the surrounding fields to inspect a greenhouse. In Florida versus Riley, Justice Brennan, joined by Justice Marshall and Justice Stevens, dissented. They asked, is the theoretical possibility that a member of the public with sufficient means could have hired a helicopter to look into the greenhouse of any relevance at all in determining whether Riley had suffered a serious loss of privacy? Nevertheless, the court's approach continued in numerous other areas, ranging from vessels on the high seas to looking into cars to following beepers placed in containers, as in the Minnesota case of Knotts or James Caro's challenge to a Drug Enforcement Administration operation. Now, in defense of this public-private distinction, the court has consistently cited the assumption of risk that marks entering into the public realm. We know when we go into public that people might see what we do, and they don't want to disadvantage law enforcement by saying they have to close their eyes or turn their heads away or not listen to what an ordinary citizen might be able to see and hear. And here's the rub. In the wake of new and advancing technologies, the amount and type of information available in the public sphere has exponentially increased, with deep privacy implications. Geolocational data allows the government to monitor the citizens 24 hours a day. Drones, CCTV, surveillance cameras enabled with remote biometric identifications, license plate readers, cell site data, Wi-Fi signals, IMSI catchers like Stingray that Professor Cloud mentioned earlier, and GPS chips are just a few of the myriad ways in which location information is generated. This data reveals intimate details about our lives. While we are aware that when we go outside, somebody might see what we do, we do not expect that somebody will follow us around 24 hours a day. That's kind of creepy. We have restraining orders we can get against people who do that. So why would we assume that the government could do that with access to geolocational data? The public-private distinction is similarly breaking down in other ways as well. The line between documents kept in the home or private conversations between individuals and information available to the public has become blurred. Previously, our paper documents, our report cards, our wills, our financial statements, our letters, these were perhaps held in a den, locked in the filing cabinet. They were considered private. But when that same information is stored in a digital space outside the curtilage of the home, even when owners attempt to protect it with encryption, weaker standards apply. The same is true of private conversations. Social media has changed how we interact. Some interactions are online: Facebook, instant messaging, YouTube, Snapchat, Vine. They may even be protected by passwords, encryption, buddy lists, or individuals designated as friends. But they do not have the same protections that are extended to friends sitting side by side on the sofa, despite this fact that the same conversations may occur. And the digitization of this information means not only is it recorded and accessed, but it can be analyzed and it can be combined with other data to build ever deeper pictures of our intimate lives. Other distinctions of Fourth Amendment doctrine are also breaking down. Consider content versus non-content. Perhaps nowhere is this more apparent than in the Section 215 program that was run by the NSA. Under a clause in the 2001 USA Patriot Act, allowing the government to obtain tangible goods when the government had reasonable grounds to believe that the information or the tangible goods being collected were relevant to an authorized investigation. For nearly a decade, the NSA collected Americans' telephony metadata with no prior individualized suspicion of wrongdoing. In doing so, the NSA relied on two cases from the 1970s, Miller, U.S. v. Miller, and Smith v. Maryland. These cases suggested that individuals have no privacy interests in third-party data. Here's the problem. Third-party information, and telephony metadata in particular, yields tremendous insight into our personal lives. A recent study conducted by computer scientists at Stanford University, for instance, considered for just 3 months the phone records of 546 volunteers. Looking at the numbers dialed and the patterns in the calls, they were able to ascertain highly sensitive private information. One participant spoke at length with cardiologists at a medical center, for a short time with a medical laboratory, received calls from a pharmacy, and telephoned a home reporting hotline for a medical device that's used to monitor cardiac arrhythmia. Another participant called a firearms store specializing in AR-15 semi-automatic rifles before telephoning a customer service line for a manufacturer that produces the AR-15 line. A third participant called a home improvement store, a locksmith, a hydroponics dealer, and a head shop. They volunteered for the study. He knew he was in a study. I love California. A fourth person telephoned her sister and spoke to her at length. 2 days later, she called Planned Parenthood. A fortnight later, she telephoned a clinic a few times, and then a month later called it a final time. This metadata provided insight into the participants' heart conditions, their gun purchases, their cannabis cultivation, and their decision to have an abortion. And it was a 3-month period of 500 people, a limited number of calls. Data is content, but metadata provides context for everything we do. It reveals the most intimate details of our lives, and it's far easier to sift through and to analyze than pure content. As NSA's former general counsel, Stuart Baker, explained, metadata tells you absolutely everything about somebody's life. He continued, if you have enough metadata, you don't really need content. It's sort of embarrassing how predictable we are as human beings. General Hayden put the point even more succinctly. We kill people based on metadata. Patterns in text messages, IMs, emails, or even URL visits demonstrate beliefs, relationships, social networks, without any of the content being accessed. It's more than just metadata. However, the content, non-content distinction breaks down in myriad other ways. Envelope information, for years, has been considered non-content and thus less protected on the grounds that it reveals an individual's private communications, thoughts, and beliefs. And I have 1 minute left. I'm going to touch on domestic versus international and finish with a test that I would propose. The third formalistic legal distinction, domestic versus international, proves equally inapposite to the world in which we find ourselves. To draw a line at the border and extend greater Fourth Amendment protections inside the border makes no sense in a world based on global communications. If I email one of my friends from my home in Bethesda and she reads the email while sitting at a restaurant in Napa Valley, the message may well have to go internationally, making it subject to weaker Fourth Amendment protections. It's not that the privacy interest is any different in my communication. It's just that it happens to travel internationally. Or how about cloud computing or use of Dropbox or Google Documents? Is all of this information fair game, so to speak, just because Google happens to hold the document on a server in Singapore as opposed to San Francisco? The problem, as with the distinctions between public versus private space or content versus content, have nothing to do with the interests implicated and everything to do with new technologies in a digital age. To conclude, I'd like to offer a First Amendment test of sorts to apply to these new technologies, which gets at the issues that are implicated by the privacy interests and away from these formalistic legal distinctions that really get us nowhere in a digital age. In 2014, the Supreme Court confronted the question of whether law enforcement could conduct the search of a cell phone incident to arrest. In Riley v. California, the court went on to lay out 4 interrelated privacy consequences that made the search more invasive than that conducted in a pat-down. There were multiple kinds of information that revealed much more in combination than any isolated record. The volume of data meant that one kind of information revealed even much more within that realm. The length of the records obtained, years, was of great concern, and the indiscriminate qualities. In allowing such searches, the 90% of Americans who carry cell phones would be subject to detailed search at any time. The reasoning of the court in Riley echoed what could be understood as the shadow majority in the 2012 case of Jones. Justice Scalia, writing for the court, fell back on trespass, on the geographical terrestrial assumptions in traditional Fourth Amendment doctrine. But 5 of the justices began to express unease about the way in which pervasive technologies had changed the privacy interests involved. As in Riley, what Justice Sotomayor worried about were not the public-private distinctions nor the content, non-content, but the length of the surveillance, the recording of that data, the volume and type of information obtained, and the potential for it to be combined with other data and the mass impact on our society. These are precisely the questions the court needs to frame as a test moving forward if the Fourth Amendment is to be applicable in a digital age. Thanks.
Okay, John Fry practices intellectual property law, but he also has a specialty in drone practice. So for those of you who have a high-tech bent and who are looking for practice opportunities and what we're talking about this afternoon, John is your guy. He talks about, and will talk about for us, domestic drone regulation, including rules that are developing to dichotomize police and perhaps military surveillance from private, hobby, and commercial regulation, focusing on law enforcement, privacy, domestic terrorism regulation. I'll quote you one thing that John said in his email to me that I thought was just particularly useful. Drones have changed the landscape as far as up close and personal in terms of surveillance. The analogy to satellite or higher level aircraft imagery is more than a bit off when applied to a drone hovering 100 feet over your backyard. So with that, I turn it over to you, John.
Thank you. And I want to thank Emory and Katya in particular and my panelists for allowing me the opportunity to do this. Just like, I have to do the disclaimer, just like Colonel, and I will skip on past that. So what I'm going to talk about is I've said it, that's all I need to say. And I only got 12 minutes, so I can't linger on it. What I want to talk about here is where the regulations are currently at the federal level, a little anecdotally about the state level, and local level, and what that does in terms of gaps that are created that create some of the issues that Laura was talking about and what I mentioned in terms of 100 feet over your backyard. And then a little bit about why do those gaps matter. I think those are somewhat obvious, but I hope what I have to show will help drive that point home. Under FAA regulation, there's basically 3 parts. There's public uses, there's the hobby uses and commercial, and the reason I have the arrows drawn that way is because essentially if it's a public use, it has to meet a certain definition. And if it doesn't meet that definition, it falls into the commercial. So what you might think of general public uses like police surveillance and things like that would fall into it. Anything that might be compensated if it's a public function drops out of public and falls into commercial. Hobby is similar in that it's got to be purely for pleasure or recreation, and if it doesn't, it falls into the commercial regulation bucket. And these 3 things are regulated differently by the FAA, and that's why that is relevant. So essentially, the public is an uncompensated government purpose, hobby is for fun, and everything else is commercial. So on the public side, a couple of things are really important when we're talking about, especially I think this is where the interface with some of the Fourth Amendment concerns and some other things come to play. These 2 highlighted points, which are, the FAA public entities still have to submit what's called a certificate of waiver or authorization. But as it highlights here, it says, other civil certification and safety oversight regulations do not apply to public aircraft operations. Accordingly, most aspects of PAO are not subject to FAA oversight. And again, similarly, the biggest difference is the public entities self-certify their operators, and I'll talk a little bit about commercial in a minute and what the big distinction is there, and they certify the airframes. So that essentially the FAA takes the application at face value on the public entity certification of those two specific components, and they really don't regulate, how they use them. And just a couple of examples, I went through the FOIA requests for these COAs, and not surprisingly, all 4 of the armed services and the Coast Guard have them. DARPA has one, Arlington, Texas Police Department, Georgia Tech Research Institute. So a lot of these entities have applied. There you go, good plug for tech. Have these certificates of authorization as a public entity. So switching over for commercial use. Big thing here, aircraft frame has to be a registered airframe. The FAA has to be an FAA licensed pilot. So when you submit this, that could be a recreational level pilot, but it still has to be a licensed pilot. And there are the DOD, so if somebody came off active duty as a pilot, that even though they're not in the same FAA licensure structure, those qualify as pilots. And the application is done through an exemption process. Essentially right now, commercial operations are banned unless you get an exemption. And so the process is to sort of get yourself out from under the prohibition is the thought process on commercial. Okay, so when you get a commercial one, I put this on here just because I think it's important to kind of see where you can operate. So a commercial operator without getting additional permission has to be below 200 feet. They have to operate it within visual line of sight, only during daylight, and has to be greater than 5 miles from airports. The new regulations will relax a couple of those restrictions. The new regulations will turn the licensed pilot requirement into a certificate and exam process, and it'll increase the ceiling to 500 feet. But again, you notice that there's really very little in any of these things that says about where you can fly them vis-a-vis people's property, and that's the piece on hopefully will become evident as you look through these. Now, the personal hobby use, and as I said earlier, that's anything that if it's for recreation or for fun, and otherwise it's commercial. They have to be registered with the FAA. This just went into effect on the 21st of December. They anticipated that essentially leading up to the holidays, that 750,000 drones would be sold, varying sizes from one in your hand to much bigger. But if the interesting piece is still hobby use, has to weigh less than 55 pounds. That's a pretty darn big drone, 55 pounds. And this does have some restrictions. It says you have to avoid populated areas, et cetera, but these are all sort of voluntary compliance things. Now, you can get in trouble if you violate them, but there's really very little enforcement, and that's one of the concerns. And in the 6 weeks since that registration process went into effect, 325,000 registrations they just passed that number, and that number in 6 weeks exceeded the number of licensed pilots in the United States. So it give you an idea how fast these numbers are moving in terms of concentration potential drones flying around. The numbers are quite stunning. But even though it's 325,000, it's still half of what they estimated to be sold. So state and local regulation is a mess. It varies everywhere from certain ones that are somewhat privacy-oriented, like the Florida statute, and that covers Florida. Chicago has one that's very similar, but a little bit different. State of Illinois doesn't have one, so if you're within the city limits, it's one set of rules. If you're outside the city limits, it's another. DC's got a no drone zone, and Reagan National has a 30-mile exclusion. Most of the places it's 5 miles. I think the people who live close to Mount Vernon and they're flying their drones in their backyard probably don't realize they're in a no drone zone. And then just as recently as December, the city of Miami was trying to put in place some restrictions, and the FAA lawyers called them on the phone and said, you need to drop all the ones that have anything to do with height restrictions or anything else, because that's our job, that's not yours. So now you're getting this FAA preemption thing into the mix, which is going to be interesting to see how it plays out, because some of the things like the Chicago ordinance also included those, but I think the FAA has finally reached the point where it's a little fed up with people trying to work in its space. So the gaps, because this is where it's important, I think, because this technology has created some real limitations on the regulation that's out there. You know, the FAA's regulation of public operations is limited, so the use of these things, particularly in law enforcement or things such as that, the FAA was taking very much of a hands-off approach. So if it's going to get regulated, it's going to have to get regulated somewhere else. Their ability to enforce the regulations in commercial and hobby operations is very limited. They don't really have a law enforcement arm to speak of, so there's not really much they can do. And if you think about how far spread those 325,000 hobby drones are, whether they're really hobby or not is another question altogether. So it's, that raises some real interesting problems about how do you deal with this. The closest thing, and I'll defer to the other panel members, but the president came out with a presidential memorandum. I guess it's really not an executive order. I think it's different, but I used the wrong word. But it, on 2/15 of 2015, essentially trying to put some accountability over how the federal government uses these in various capacities. But again, that's still the federal government. That's not, you know, state and local governments, state and local law enforcement. So you have this real patchwork of things, and from a commercial operator, if you were doing like I would do in counseling a client who's a commercial operator of a drone, one of the biggest things is that, well, if you're operating in Georgia, it's one thing. If you're operating in South Carolina, it's another thing. So there's that aspect of it, but also from the standpoint of, again, this whole issue of law enforcement, some of the states have prohibitions on certain things, others don't. And for example, only 3 states currently ban arming a drone. That's Oregon, Virginia, and Wisconsin. More states ban using a drone in connection with hunting and fishing than ban arming. I mean, so I mean, it's a very interesting prioritization. Michigan, I like Michigan. Michigan's a wonderful place, but its drone regulation all deals with hunting and fishing. The last piece, and this was just a sort of, again, an anecdotal how everything gets to be such a mess, is there was a bill went to Governor Brown's desk in California in August, I think it was, September, and it was a fairly comprehensive privacy, lots of other regulations on drone operations, and he vetoed it. And a month later, because of a lot of pressure over sort of paparazzi aspect of it, he signed a very narrow one. So what you're getting is this very odd landscape of regulation, which is clearly going to be ineffectual until we start to establish some parameters for this. And this is, so why do they matter? I hope you'll be able to see this. I'm afraid you might not. This was shot in Germany. It's won the Guinness Book of World Records.
Everybody ready?
Hold drone switched on. And these were all programmed by computer and by beginning to the end. So there's nobody actually programmed this sequence. At the end of the actual thing, it was all by sponsored in part by Intel, so there's this big thing when they fly in a circle and it spells out Intel in the middle. It does the little Intel, boop, 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 the little jingle that it has. But I needed to cut that down a little bit. So why? Okay, so that's amazing. 100 of them flying. Hopefully none of them collided into one another. But a very coordinated, computer-controlled evolution involving 100 drones. This is an 18-year-old kid who built a kit drone in his backyard and mounted a 9mm handgun to it. So let me ask you, the first one plus the second one, there's a real potential security risk associated with what you could do with these things in a coordinated effort. It's not just, a handful of people piloting them individually, but a coordinated effort with a lot of computer controls, with large numbers. What's the other thing about ants overwhelming larger creatures from a military perspective? So that's, I think it all of this area, the drones, the regulations, what's going to be done with them creates a lot of interesting security problems. Thank you.
Thank you. That was terrific. As I read it, John, I guess Laura can fly the drone she's making as long as she stays out of the 30-mile zone of Reagan Airport, and she can arm it. And since she's not the government, she wouldn't have a Fourth Amendment concern spying on someone outside that radius.
Something like that.
But there are federal regs. It would be a destructive device under the laws.
Okay, so our next speaker, Peter Swire,
Needs tech help.
What?
I need a tech assist. I can't get my slides up.
Tech assistant? Oh, okay.
Sorry.
Oh, okay. We got to get out of one set of PowerPoints and into the
There's
next.
a mouse. I didn't see the mouse. I was trying to make the thing. Okay, that's fine.
Okay.
Okay. As
You
you
may have to
tell
push
from
the
your
slide.
brochure, Peter has deep experience with respect to privacy-related issues, going back many, many years, and we are very fortunate to have had him recently move to Atlanta and to Georgia Tech, and he is very much involved with trying to shape issues of NSA regulation and effectiveness of counterterrorism efforts. Hopefully, I think what he's going to do is talk about a larger project of his, which is ongoing at present, and that is how to reform mutual legal assistance programs between countries concerning law enforcement requests in an era where different countries have very different perspectives and agendas in connection with data exchange and data usage. So,
Great.
take it away.
First of all, can I see the fireworks show that comes with drones flying around with fireworks? I mean, what an amazing world we're living in. That's great. And it's great to be at this conference. I'm at Georgia Institute of Technology now, and a lot of our themes are how technology and law are coming together, and I think having collaborations between technologists and lawyers is a great thing to try to work towards. What I'm going to talk about today is how changes in global communications, the technology changes, are creating certain kinds of challenges. So cross-border data flows are common and increasing for cybercrime, attacks from China, Russia, wherever. Other crimes, which we'll talk about, cybersecurity and national security. It's just a common feature of the internet that we're going across borders, as Laura Donahue, among others, reminded us. And the law enforcement part has large national security implications. We're talking about war and national security today, especially for counterterrorism. And as we heard this morning, criminal law is part of what can be called the all-tools approach for counterterrorism and national security. One of the ways you can stop a terrorist attack is to put the potential terrorists in jail before they attack. And so criminal investigation is a big part of national security now. But the main puzzle today is we have strict U.S. privacy law that creates obstacles to the European Union when they request data. And by the way, we have strict European Union privacy law that creates obstacles when the U.S. wants data. And so what are we supposed to do in this mess, which has not been sort of worked through in a very systematic way yet? The context for this talk is several papers we've been working on. I'm doing a research project with Justin Hemmings on mutual legal assistance, and we also, Suzanne Vignol, a French lawyer, doctoral student, is with us working on that this year. And so there's a couple of recent articles about this mutual legal assistance. How do we share records globally between the U.S. and other countries for law enforcement? And then a second project, and DeBray Kennedy Mayo, who's Emory class of, I think, Emory Law class of 99, I believe. DeBray is here today and is working on this. Has to do with the European safe harbor discussions that have been happening, the Schrems case where Facebook and safe harbor got struck down in the European Union. So we have European Union with strict privacy rules from Europe, and we have MLATs with strict privacy rules in the United States. And the paper for Emory and the talk today is bringing these two parts together. So here's the puzzle. For a minute, imagine yourself in the United Kingdom. You're helping the Prime Minister, you're helping law enforcement in the UK. And last week, the Washington Post ran a story that said the UK and the United States have agreed that if it's enacted or takes a legal change in Congress, it would allow the UK government to go right to the providers, Facebook, Microsoft, Google, whatever, go to the providers in the United States for stored records for at least certain things. So UK police would say, we want this, the records are in the US, and instead of having to go through that darn American legal system, the agreement would be that the UK government would talk to the companies in the UK and bring records over from the US. A little more surprising is a UK legal order could authorize wiretaps in the United States, that the data then goes to the UK with no involvement from the US legal system. And even maybe more important or surprising is they could do national security, not just law enforcement things this way. So this is a proposal. There's a draft agreement that our government has signed. This is a big change. Wiretaps in the United States with no US judges involved. It's a big change. We should notice that. So I've been working, as other academics and others with civil society and industry, on a group about these issues. We're working to get a statement out about how you should have privacy and human rights built in if you're going to allow the UK government to start doing wiretaps in the United States. And so we'll see how that works out. But I'm asking, you can see the privacy issues if wiretaps get authorized in the UK and the US. But I want you to sympathize for a minute about the United Kingdom police and national security folks. So for stored records, like emails, social network, think about if there's a UK victim, let's say for a burglary, and it's UK suspects, and they were using email or social network where the records are stored in the United States. But it's a UK crime, it's UK victims, it's UK suspects, it's all UK, and they cannot get the records unless the US helps them. That's very annoying and hard for the United Kingdom police or the French police or German police or whatever. And for wiretaps, and we talked a little bit about encryption this morning, that's been a thing I've tried to study for years. We have Alice in the UK who's emailing Bob in the UK, or maybe Skyping or FaceTiming with Bob in the UK. But it's encrypted, right? So webmail is typically encrypted today. Skype and FaceTime are encrypted today. And so there's no wiretap in the United Kingdom that works. It just gets encrypted ones and zeros. So if they want to intercept something, they have to go somewhere where it's open on the server. So if you have a Gmail account, it's encrypted to Google, but Google can see the words. And so the game becomes getting Google to open it up at that moment in the United States when it's readable. But they can't do wiretaps anymore. That's very frustrating to governments that lost the ability to do wiretaps. And for national security investigations, we're good friends with the United Kingdom. We do Five Eyes and all that. But they might not want to share and ask the United States every time they do a national security investigation. Right? Countries don't like to have every investigation going through their friend. They might want to be able to do those investigations themselves. The point here is that technology, encryption changes, global flows changes have meant that the UK loses the ability to do stored records, to do wiretaps, and to do national security investigations today unless they get US cooperation. That's a big change in the way law enforcement and investigations go. It's an area, if you were the UK law enforcement, you'd be very annoyed by this. And they are. They're very worried about it. So this slide is about US privacy law. And this headline, US privacy law is stricter than the EU, would not be believed in most of Europe, right? The European view is they have privacy laws, the US doesn't. But when it comes to, that moved faster. So when it comes to ECPA, the Electronic Communications Privacy Act, the US law is stricter in many respects than the rules in other countries. So in most countries in Europe, there's no judicial oversight before the emails get turned over. There's no probable cause requirement or a reasonable articulable suspicion requirement before metadata and rules and content get turned over. There's no notice to the service provider of the legal basis of the request. These are standard things in US law enforcement investigations that do not exist in other countries. And also First Amendment. In Europe, Nazi speech is often a hate speech and it's a crime and you can't do it in Europe, but in the United States, it's First Amendment. You're allowed to say these things about, we might dislike you deeply for doing it, but we're not going to provide evidence around hate speech. So what we have when Europe and the United States are debating this, we have these mutual legal assistance treaties. And today's system is there's careful review in the United States Department of Justice in their Office of International Affairs. And they review each request from England or other places. And there's, even if you get it, if they qualify for all the US standards, it takes 10 months or a year to get it. There's police hot on the track of some investigation. They can't get evidence for a year or whatever. Very frustrating. So the EU perspective on this part, on wanting to catch their criminals and their terrorists, is that there's lots and lots of evidence held in the US by the global service providers, Facebook, Yahoo, Google, et cetera. And the US won't provide vital evidence even when it's EU interests at stake. It's EU victims and crimes and suspects. So there's frustration from the law enforcement, national security side in England and other places because the US law is too darn strict. This headline, EU privacy law is stricter than the US, that's what people in Europe believe, and that's what's commonly said in the US, and it's true in important respects. So for the United States, we seek to export data or criminal evidence from Europe for a lot of reasons. For commerce, we have lots of data for business that comes across the ocean. We have the Safe Harbor Agreement with Europe that we've had for the last 15 years. We do global services with lots of things. So we want to get data from Europe to here to help us do our business. We want to get data from Europe for law enforcement purposes. We're allies. We ought to get along. We should share this information. But EU has strict laws, and the 1998, they had their data protection directive that went into effect. They've now approved a much stricter new set of privacy laws called the General Data Protection Regulation. And the European Court of Justice, their highest court, which binds the member states, decided in the Schremm case in October that the whole Safe Harbor Agreement was illegal, and maybe transfers to the United States very broadly are illegal under European fundamental rights law. So now there's negotiations about the stricter EU privacy rules. We've had this Safe Harbor update called Privacy Shield that was announced last week for new rules for commercial practices and some U.S. foreign intelligence practices. We have a law enforcement agreement that the U.S. has signed on to. So the U.S. has now promised not just how we collect data, but we've promised for law enforcement we're going to use the data under certain rules, and we're going to limit downstream disclosures under certain rules when it comes from Europe. So we're putting in place new legal mechanisms to sort of shape data held in the United States. But the U.S. perspective is this is frustrating. There have to be some limits on what EU insists in terms of changing U.S. practices. They shouldn't tell us how to run our internet and all our companies. So you might call this mutually assured frustration, right? That's I came up with that last night. It might not be very good. I haven't Googled it to see if anyone else has used it, but it's not as good as MAD, but it's close. Okay, so human rights advocates on both sides of the Atlantic can't imagine lowering their standards. Imagine going to U.S. human rights civil liberties people, and they say, don't worry, we're not going to have judges, and we're not going to have probable cause, but trust us, it's going to be okay. That's not going to be great with the ACLU, right? And in Europeans say, well, you have no comprehensive privacy law like ours, and you don't have any control over the data once it's collected. And plus, the NSA makes the U.S. an unsafe zone for data anyway, so we don't trust data in the United States. So the human rights people, civil society, ACLU types on both sides are really frustrated by the other side of the Atlantic. They can't imagine the compromises that would be needed to fix this stuff. But in our era of global communications, blaming each other, no, it's Europe's fault, nor it's the U.S. fault, and blocking legitimate data flows, there's a real crime we're trying to catch here. Among allies, just sort of blaming it and blocking it is not the right way to proceed. And so we ought to move towards new agreements to have effective data flows under law and also follow privacy and human rights laws and norms. It's a complicated area of law. You've got European law, you've got US law, you've got criminal law, national surveillance law, privacy law, but we ought to work our way through it and come up with some ways to handle these global challenges. So last slide. Just some preliminary thoughts on the way forward. First is, we have to describe the situation, right? How many people have ever studied MLATs at any point in their life here? Well, that would be one who works with me on the subject. Okay, 2 other people. Okay, but mutual legal assistance, every criminal investigation when data flows across borders might require cooperation with India or with Europe or whatever. So this is a pervasive fact of modern data flows, especially for European law enforcement that can't get any emails, basically, unless the US cooperates. So that's describing that and realizing there's a problem. You can't solve a problem until you've described it. So in technology, there's so many new data flows. On law, we have now tried to identify why each side distrusts the other's approach and can't imagine the compromises the other side lives with. Once you describe it, there has to be a sort of education and debating process among the elites. People are prone to criticize anything that changes their system. But we can't live with both systems blocking each other. That's not a good outcome. So we're going to have more conversation, hopefully lots of really nice trips with good restaurants across the ocean to, but seriously, there's going to have to be an education process here. Then once we've described it and we've started to talk amongst the people who work on this, we have to identify concrete reforms that will enable the legitimate data flows. If there's a crime and it's an emergency or it's legitimate, we have to enable it, and we also have to honor the core legal principles for each country. And that's between the US and EU, where they have rule of law systems, lots of relationships. How do we consider how to expand this beyond the club of just the US and Europe? India's got over 1 billion people in it. They use American services all the time. What are the rules going to be for India, for Africa, and the rest of the world? So how are we going to address legal rules across that for 200 nations? How are we going to build in privacy in a sensible way? How do we protect human rights as we expand past the club of democratic nations in Europe and the United States? This is not all going to get solved in the next couple of weeks or months or anything, but one hope of the research project is to put it on the agenda and make people realize we're probably going to have to figure out some changes here. Thanks very much.
Thank you, Peter. You've elucidated a big problem, but maybe there will be some good dinners that come from it. So, at any rate, Rachel Levinson-Waldman, our final speaker for the day, is going to confront the idea of the surveillance state, discussing surveillance in public spaces using developing technologies such as surveillance cameras, license plate readers, cell phone trackers, and so on and so forth, and how this intersects with national security, especially with regard to, say, the special needs doctrine, and how mission creep, which Morgan Cloud mentioned earlier, goes from national security to domestic law enforcement to civil regulation, and how you can minimize or eliminate those sorts of mission creep things. At any rate, she may also address other aspects of the surveillance state, from drones to biometric identifiers to anything else she wants to, because if you go to the Brennan Center site, you'll see that she's written about virtually all of them. She writes some very interesting short pieces in many instances, though she's now working on a long law review article that hit almost all of these individual areas. Rachel?
Thank you so much. And I'm thrilled to be here, and it's also nice to see what a big crowd we still have after lunch. That is very much a testament to the organizers and to everything that they've assembled here. So I really appreciate being part of this. So I am going to jump off a little bit from what Professor Cloud was talking about in the last panel, and also in some ways sort of take us full circle. Obviously, Laura gave a really compelling description of kind of what's happening in terms of surveillance, these distinctions that are breaking down, and relating very much to these surveillance technologies in public space. So I'm going to bring us back to that in a couple of areas. There are two pieces that I want to talk about, and I'm hoping at the very end, if I have time, I might be able to talk a little bit about the metadata piece, but if not, then maybe I'll do that afterwards. So there are these categories. I mean, one of the things that Laura was talking about is there are these categories that are kind of collapsing, which I think is a very good way of putting where we are now. They're categories that have kept a lot of individual power, and that's kind of what I want to talk about, but where there's also a lot of slippage. So that's kind of terrorism and national security on the one hand, and regular criminal law on the other hand. As a matter of fact, those are quite significantly collapsing into each other. And that's the first piece that I want to talk about is sort of I'd been thinking about it as mission creep. I think Professor Cloud had used a term which I like, which is sort of spillover. There's some fluidity. So I want to talk about that. And then second, in some ways, why that matters. And that's going to take me into the special needs doctrine, which sounds very dry, but actually is interesting and will really sort of get us into some of the terrorism and national security issues. So to start with sort of this mission creep piece, which is to writ large to say that there are technologies and kind of methods of information collection, governmental information collection, that have been justified on the grounds of national security, that have been rolled out on the grounds of national security, and now are being brought into sort of the regular criminal realm. And again, this very much sort of links to what Professor Cloud was talking about in the first panel. And I want to give a couple of examples to make those somewhat concrete. So the first example, I don't know if people are familiar with this, fusion centers. So fusion centers were rolled out several years after 9/11. They were one of the things recommended by the 9/11 Commission as a way to basically help connect the dots. So the idea being post 9/11 that the failure hadn't really been a failure of information collection. There was tons of information. There was potentially too much information. But that in part there was a failure of communication and figuring out how to communicate even within the parameters that existed. And so one of the things that was recommended were these fusion centers to help bring together partners, local, state, federal, private partners together to share information, which sounds like a good idea. The purpose, obviously, coming out of the 9/11 Commission was counterterrorism. As it happens, though, terrorism is very, very, very rare. When it happens, it is obviously terrifying. It feels like an existential threat. Obviously, there were huge harms that came out of 9/11, but it doesn't actually happen very much. So because of that, these fusion centers that have been funded with huge amounts of mostly untracked DHS money were kind of sitting around with not that much to do. So there was this mission creep from counterterrorism into, many of them are now called all hazards or all crimes. So to some extent, they combat serious crimes, as was talked about in the last panel. So maybe it's not national security, but it's major. Maybe they're helping to track down a kidnapper. Maybe they're helping to track down an escaping murderer. On the other hand, in some cases, maybe they're helping to combat thefts from bakeries, which is one of the things that one fusion center sort of touted itself as having done. On top of that, there was a Senate subcommittee report in 2012 that dug into fusion centers. Okay, how are they doing at their job? Actually, it turns out really, really badly. Whatever you think their job is, mostly what they're doing is, in the subcommittee's reports, producing reports that were shoddy, rarely timely, usually endangering citizens' civil liberties, and more often than not, unrelated to terrorism. So there's this huge kind of grant of authority and money that's really coming from national security purposes that ends up getting very spread out and kind of affecting everyone. The second example is the use of NSA surveillance in the drug war. So in part, the kind of classic, actually gathering intelligence, listening in, using information gathered from wiretaps to help fight the drug war. There's also, as it turned out and as we've learned relatively recently, enormous surveillance that the DEA and DOJ themselves were engaged in that actually turns out to kind of dwarf what the NSA was doing. So the mission creep kind of went in both directions, from the drug war to sort of overseas technology, but then also very much from this authority to do national security surveillance that has then kind of been brought back domestically. So there are statistics, there are these things called sneak and peek warrants that were authorized in the Patriot Act. They're authorized mostly on the grounds of fighting terrorism. The idea is that you can kind of you can sneak in and look at something without providing notice. The grounds was there are these really serious national security threats, but in fact, most of them are used for drug investigations. They're mostly not used in terrorism cases. And then the third one, which connects also to something that Laura's talking about, is cell phone tracking. So, to the extent that you think about it, to the extent that this is something that's on your radar, we think about it mostly in terms of how is it being used domestically. In fact, as far as sort of I've been able to tell from what I've been reading, this is something that originated overseas. So the idea was that this technology was going to be used to track insurgents overseas as part of our wars overseas and as part of sort of national security concerns. There was a company, which Professor Cloud mentioned, Harris Corp, which manufactures these stingrays. They basically saturated the market overseas, but they have this amazing technology. So where is it going to go next? The answer, as with a lot of sort of hardware that starts overseas, is that it's going to come domestically. So then stingrays start being used by the federal government, by FBI, DOJ, DHS. They are a super big hit and super useful. So then where are they going to go from there? Again, this is also super money making for Harris Corp. Is they're going to go to local and state law enforcement. And by and large used, not for terrorism cases, a lot of drug cases, some really significant cases, but then also, somebody takes a laptop, somebody takes a purse, there's a robbery on the street. you have this great technology, that's what it gets used for, largely, as Laura said, as Professor Cloud said, in secret with very little oversight. So there's this, whatever you want to call it, mission creep, kind of fluidity between national security and domestic issues. And so partly there's a question of, okay, well, why does that matter? You know, maybe this is useful for a variety of purposes. That's fine. They're law enforcement purposes. Maybe we're comfortable with it. So obviously one reason it matters, which I won't be getting into a lot, is the transparency issue. When something is justified or rolled out on the grounds of national security, it tends to be kept very secret. There tends to be very little transparency. So that's obviously a big issue. One of the other reasons it matters is the second piece that I want to get into, which is that there are, and this is connected, but there are actions, there are governmental actions that are kind of authorized, whether explicitly or tacitly on the grounds of national security, that wouldn't be sanctioned otherwise. And sort of the avenue to talk about this is this special needs doctrine, which is basically how you can engage in something that would otherwise be a Fourth Amendment search, but without a warrant. And there are certain narrow grounds in which that can happen. So the basic background to this is a 1967 case called Camara, in which the Supreme Court said, yes, these things called administrative searches of private homes are fine. You have to get an administrative warrant, but it's not a kind of classic probable cause warrant. The idea is that you're going in, an inspector is going into a home to check for safety violations. They have to be able to do that. They won't necessarily know about the inside of that particular home, but it's so important to be able to check for kind of major structural issues that these can be authorized as long as there's some kind of elements of a framework that are met in terms of, you know, it's been a particular amount of time since an inspection. There's reason to think that you would need to go in. So there's some problems with that, but it's relatively narrow. It's then expanded in a case called TLO from 1985, a concurring opinion from Justice Blackmun. So in this case, there's a student in a high school whose purse is searched by the principal without a warrant. The principal finds rolling papers and money in it, and then the student tries to suppress it. The Supreme Court says, and especially Blackmun in this concurrence, there are exceptional circumstances in which special needs beyond the normal need for law enforcement make the warrant and probable cause requirement impractical. And then the court can substitute its balancing of interests for that of the framers. Meaning the framers have decided, usually if you're doing a search, and it's a Fourth Amendment search, you have to have a warrant. And that's the balance, it's sort of done. But there are some circumstances, if it's beyond the normal need for law enforcement, when then the court can do its own balancing. And in a subsequent case in 2000, the Supreme Court said, programs undertaken to detect evidence of ordinary criminal wrongdoing, even where the gravity of the threat is high, cannot be justified as a special need. So obviously one of the questions here is terrorism a special need? And this doctrine has had really kind of special force where the government says it has an interest in preventing acts of terrorism and other crimes. But some courts have pushed back against this, and especially in light of that mission creep. So one of the cases that I'll give an example of, there's a case called Bourgeois v. Peters from the 11th Circuit. It's a 2004 case. And this was a case about having protesters at the School of the Americas in Georgia have to go through a magnetometer to get into a protest area. So basically a metal detector to kind of be searched. Is that a reasonable warrantless search? And it was justified on the basis of terrorism. There's a threat, maybe there's a big threat. The history didn't really bear that out. There hadn't been major violence at previous demonstrations, but the city said, look, we want to have all the demonstrators go through a magnetometer so we can be sure they're safe. So the court says, while the threat of terrorism is omnipresent, we cannot use it as the basis for restricting the scope of the Fourth Amendment's protections in any large gathering of people. And the court, again, this is the 11th Circuit, goes on to say, both protesters and passersby might be safer if the city were permitted to engage in mass warrantless, suspicionless searches, but nevertheless, there's this value judgment that's embodied by the Fourth Amendment that can't just be overtaken by kind of a mention of terrorism or national security. So there are certainly cases, there are certainly courts that have said, yes, terrorism is a special need, or they've assumed that's a special need, and so you can undertake searches that would otherwise require a warrant. But even in those, there has to be some kind of fit between between whatever the government wants to do and what the threat is. So is the action, whatever the search is or whatever the surveillance is that relatively narrowly tailored to the risk at hand, or is it out of proportion? So there's a case from 2004. There were demonstrations planned in New York in the ramp up to the 2004 Republican National Convention. So in preparation, the NYPD came up with a plan where they were going to search the bag of every attendee at the demonstration. So New York City had said that because the federal government believed that the convention could be a target of terrorist attacks, there could be an increased risk of violence or threats to public safety if the NYPD couldn't conduct this kind of dragnet bag search. And the city said, the court said no. There was kind of this general invocation of terrorist threats, but there wasn't a showing of how the searches would mitigate the threats. Is that my 1 minute warning? Okay, all right, I will try to shove everything into my remaining minutes. There are a couple of other cases in which courts either say, look, you haven't shown us enough, or yes, you've shown us enough, but what you're doing has to be pretty narrowly tailored. So, bringing us around finally to surveillance. This is very much an open question. Is any surveillance, does it count as a Fourth Amendment search in the first place? But if you're just thinking about questions, say we assume that terrorism is a special need, and that, so what does that mean? Sort of could surveillance be deployed? Is it relatively narrowly tailored to satisfy that need or to help to solve it? And in fact, the evidence suggests no. So for instance, taking surveillance cameras as an example, after the Boston Marathon bombing, there was a big push for more surveillance cameras. But by and large, that's because the surveillance cameras helped solve the case, not because they helped deter the attack. And by and large, that's the case. So there have been a number of studies looking at surveillance cameras that suggest that mostly, there are some exceptions. If you're talking about things like vehicles being stolen, if you put a surveillance camera inside a parking garage, that may have some deterrent effect. Mostly what surveillance cameras do is that they solve crimes. They don't deter crimes. And so if you're thinking about this question that we're asking in terms of special needs, that it has to be, whatever you're doing has to be for the purpose not of garden variety crime, understanding that terrorism feels like an existential threat. At bottom, what you're doing, either the surveillance cameras are going to deter it, but they don't, or they're going to solve it. At that point, what you're doing is solving a crime. So I think it's not clear to the extent that special needs comes up and sort of this suggestion that, well, we can put a lot of surveillance out there if the surveillance is a search, and that's something that I'm sort of assuming here for some kinds of surveillance, by no means all, then surveillance isn't really doing the things that would justify using it as a response to terrorism and national security threats.
Okay, thank you very much. Any of you who have... We only have about 15 minutes for questions, so if anybody has questions, please go to the two microphones back there. I'll take the chair's liberty of asking the first question, and that is basically that 9/11 led to the USA Patriot Act and substantial metadata collection under Section 215. Snowden revelations led to the USA Freedom Act and some restrictions on that. And I'd just like, each of the panelists in various ways have alluded to Section 215, and I'd just like to see if we can get a little bit of clarity about what has changed and what is still not good enough if that's the way you approach this with respect to the 215 metadata program. Who wants to start?
Let's go down the road.
Could just go down the line?
Yeah.
I think we probably all have something to say about 215. So to be delicate about this, in my view, 215 is neither legal nor constitutional, the way it was applied with regard to the telephony metadata program. The language of the statute required that the tangible goods, that the government have reasonable grounds to believe that the information being sought was relevant to an authorized investigation. That's the exact language. The government's argument under Section 215 was all telephony metadata is potentially relevant to authorized investigations. That's the language used. Therefore, we can collect all America's telephony metadata. So here's the problem. If that's relevant, nothing is irrelevant, right? So it reads the word relevant out of the statute. And it's not actually an authorized investigation, as the statute requires, it's all investigations. And if you read the statute language that way, you also read reasonable grounds out of existence. So the very way in which it was being interpreted secretly behind closed doors without anybody having access to how this was being applied was rather extraordinary. Under the government's understanding as well and their interpretation of this, by the way, not just telephony metadata, but actually all financial records are potentially relevant to authorized investigations. So are all gun records. So are all education records. In fact, there's no limiting precept, unlike the congressional language adopted in the statute. So as a purely statutory matter, it was illegal to understand the statute in this way. Beyond that, I would also suggest that it's unconstitutional. The Fourth Amendment was founded as a prohibition on general warrants. The history on this point is incontrovertible. I write about it in the book. I have a law review article coming out with the University of Chicago. It's about 100 pages on the origins of the Fourth Amendment. It's very clear that the founding generation adopted the Fourth Amendment to prevent the government from being able to obtain warrants without specifying an individual to be placed under search, without naming the place to be searched, without specifying a crime, without establishing under oath probable cause that an individual had committed that crime. That's a general warrant. And essentially the Verizon order does exactly what the founding generation sought to prevent. Now the government points to Smith versus Maryland, which was the case I mentioned earlier, to say that this is constitutional. This is simply third-party data. In my view, that is a misreading of the privacy interests that are involved in this case. So Claire Egan, who was the one who approved this program, by the way, the order approving it and the memorandum actually justifying the legal rationale did not go into place for years after the program had already been operating. The program had been moved over from the terrorism surveillance program and kind of shoved into FISA, and which required this kind of gymnastics reading of the statutory language because they wanted to find a way to preserve a program they had introduced outside of FISA, which by Congress's statement in FISA was unconstitutional, that the only way the president could conduct this kind of surveillance was through FISA. The president did this outside of FISA, then tried to move it into the statute by reinterpreting the language in this extraordinary way. That language is just patently, it's an unconstitutional violation of your right not to have the government cast around looking for potential evidence of wrongdoing and then using that as a way to go after individuals. And the reason why is because this gives the government too much power. If you allow the government that kind of information, they can select who their enemies are and then just cast about and try to find some evidence of illegality or to embarrass you or to use it as a way to control you or as a way to manipulate your social networks. This is what the founding generation was really worried about. And I just want to comment on Rachel's point. And Professor Cloud about mission creep and spillover. In the book, I call this convergence. We are seeing a convergence between national security and criminal law. We saw it with Shamrock, we saw it with Minaret, Operation Chaos, Operation Conus in the 70s. This is not a new thing. What is new is we're seeing both data convergence and institutional convergence. So when the wall came down for the Foreign Intelligence Surveillance Act, you can now use foreign intelligence surveillance powers even when the primary purpose of your investigation is criminal in nature. Now, there are much lower standards adopted under FISA than what we have under criminal law. In criminal law, for a Title III search, you have to have probable cause that a crime has been, is being, or will be committed. Under the Foreign Intelligence Surveillance Act, you simply need probable cause that an individual is a foreign power or an agent of a foreign power and likely to use the facilities to be placed under surveillance. The standard of review, the notification, the minimization requirements, the sealing requirements, all of these differ between Title III and FISA. So the idea that the government can now use FISA to bypass the criminal realm, and of course we've seen Title III applications plummet and FISA applications increase as soon as the wall came down. That's one of the ways in which we see this convergence with and also the questioning of 702 databases. The FBI queries 702 data under the FAA without actually looking at any connection to foreign intelligence. This came out in the recent report of the Civil Liberties Board. And then finally, the institutional convergence that we're seeing that Rachel touched on with the JTTFs, but we're also seeing it with next generation identification and DoD's access to that, and with the FBI's dual-hatted responsibility between criminal law and national security measures.
Other panelists?
I just like to. I have one.
Equipped to respond to
I have
that.
one quick point. So one of the changes in the USA Freedom Act is that up until then, when the FISC, the Foreign Intelligence Surveillance Court, was making its decisions, it was always ex parte. The Department of Justice was there, but there was nobody giving another perspective. And one of the reforms that the review group I was on approved of, and that now is law, is to have 5 outstanding lawyers as amici who will now give a different perspective. Professor Donahue is one of those 5 lawyers. I think she will give a different perspective to the court, and it's a sign of creating new institutions and new ways to put challenges even inside the national security realm so that we make sure that our values are upheld over time.
Okay, let's take some questions from the audience. Got 4 of you at least in line here.
Hi, my question is, how do autonomous drones, like the ones Amazon is researching right now, how would they fit within the FAA's regulation, and I guess specifically the commercial regulations?
Sure. Right now, I mean, technically speaking, because of the visual line of sight restriction, they can't do that. There's a lot of effort going on. The FAA is coordinating with different industries to try and figure out ways to expand beyond the visual line of sight. The hardest one that's going to be probably the toughest nut to crack is going to be having it land in your backyard, simply because of the concentration of trees, power lines, all the different things that would come into play. Plus, I mean, can you imagine sitting in your backyard, watching 5 o'clock delivery time, and half a dozen of them are flying around your neighborhood? So there are a lot of challenges to that. It looks very fun to watch on the video, but there's going to be some real technological hurdles to get that to a point where it can be really viable. They're working on it. I mean, there's no question that's happening. And will it happen in the next year? I doubt it. Will it happen in the next 5 years? I expect it will.
Can I just add to that first-person view, FPV? So they're interpreting line of sight to exclude first-person view. This is when you put goggles on and you can fly your drone and see what the drone sees. And they've just announced that their interpretation of the 2012 legislation and the subsequent regulations includes FPV in this, which actually is hitting hobbyists very hard. So now we have to register our drones as commercial if we use goggles and first-person view on the drones, which will affect commercial interests as well.
I got a mini drone for Christmas and can't control it myself. So. Okay, next.
That's a virtual reality.
Yeah. I want to go.
Hi, thank you all very much for being here and for your time. This question, I guess, is mostly for Laura and Rachel, but I'm happy to hear anyone chip in. So the objective prong of the CATS test, which asks whether a subjectively held reasonable expectation of privacy is one that society is prepared to accept as reasonable, always seemed to me to be not only, a bit circular, but also a pretty depressing tautology, because the more that we learn about pervasive surveillance, the less we can reasonably, expect to be, our homes to be private. So I'm wondering if you think that there's any chance to really have a robust freedom or a privacy doctrine within the CATS test, or whether you think you need an entire abandonment of the doctrine. So some courts, like the DC Circuit preceding Jones, had proposed this mosaic test, where the whole is greater than the sum of its parts, so that maybe you can say that many individual non-searches taken together would constitute a search. But the mosaic theory aside, I was wondering if you thought there's any chance within the CATS doctrine to really accommodate privacy in this realm of pervasive surveillance.
Yeah, so I can speak to that, and I'm sure Laura has a lot to say as well. So I think the CATS test is very problematic for exactly the reason that you identify. And there are courts that have basically said, because the very small print of a cell phone contract says that your location information is being sent to the cell phone carrier, because of that, that information is made available, that law enforcement could have that information, thus that the police could be tracking you at any time, right? Which does sort of play to this idea of once there's this technology out there and the more that we know about it, sort of the less privacy you can expect. I do think the courts are starting to push back against that. And in some ways, I think they're actually doing it within the context of CATS. So this article that I'm working on ultimately says we can basically keep talking about the reasonable expectation of privacy. We want to tether it to some more kind of concrete factors. And this is some of what Laura's talking about as well. So you might think about, how long is the duration of surveillance? That obviously speaks to the mosaic test. You might think, and courts have talked about this as well, how much has the cost dropped? So to what extent have sort of the practical barriers to surveillance dropped, in such a way that it's so much less expensive, so much easier to do surveillance now? And I think what all of that speaks to is kind of these core foundational notions of privacy, right? What's your expectation of privacy that is not dependent on what happens to be in a terms of service contract, but what do we think in terms of how we as a society think of privacy, think about how we're able to, kind of engage in a democratic society. And I know that Margaret who's going to be on the next panel, may not be talking about this exactly, but also has some very interesting ideas on this. So I do think it potentially still fits within CATS, but the way CATS is now, which is very untethered and really kind of very much subject to the whim of how a particular judge is thinking about it, I think is very problematic.
And if you went back on an originalist view to what would the late 18th century person have expected in terms of privacy, you could get rid of all these things. Okay.
Well, actually, so
could we do
yeah,
two more
sure.
questions? Or
Yeah.
do you, I mean,
No, we're good. You're the chair.
we're about out of time, but maybe let's try one more question. Okay, I think maybe one question to one panelist.
Well, I'm not sure who to
Okay, well maybe.
aim this at, but let me see if I can say it succinctly. The panel seems to be concentrating on protecting me against the government, but this, particularly Mr. Fry's video, if I were, just to mention just one thing, if I were the head of the Secret Service, I'd be scared to death. What is going to protect us from non-government actors, these drones? What's going to protect the security? What's going to protect the safety of jetliners? What's going to protect me from that flying murder weapon with the 9mm?
Those are very good questions, and one of the reasons why I think everything from the regulation of them from the law enforcement perspective and the Fourth Amendment concerns from use by law enforcement is some of the same sort of the mirror images of the concerns that you have from them on just a general regulatory. The thing that concerns me the most is exactly the numbers that we're talking about. It used to be, if you thought about how many drones were out there operating, there weren't that many. I mean, now we've plugged almost 1 million more into the potential. If somebody were tracking purchases 2 years ago and somebody bought 1,000 of them, it would stand out. Somebody buys 1,000 of them now, you wouldn't even notice. It'd be a blip. So being able to do something like this becomes harder and harder to detect. And again, it just goes back to gathering information, different ways of gathering information. It touches on the usage, all the other traditional law enforcement questions. But I think the challenge it presents is one of, like, it goes back to the ants swarming. It's a problem. I think that's potentially a problem.
Well, thank you to everybody on the panel. I'm sorry to have to break this off, but Corky tells me I'm already 3 minutes late. Thank you so much. All of you did a great job.